Yo. Evidence. Chapter 3. Judicial Notice and Judicial Admissions. A. Judicial Notice. 1. The relevant provisions on judicial notice under Rule 129 provide, Section 1. Judicial notice, when mandatory. A court shall take judicial notice, without the introduction of evidence, of the existence and territorial extent of states, their political history, forms of government and symbols of nationality, the law of nations, the admiralty and maritime courts of the world and their seals, the political constitution and history of the Philippines, the official acts of the legislative, executive and judicial department of the Philippines, the laws of nature, the measure of time, and the geographical divisions. SEC. 2. Judicial notice, when discretionary. A court may take judicial notice of matters which are of public knowledge, or are capable of unquestionable demonstration, or ought to be known to judges because of their judicial functions. SEC. 3. Judicial notice, when hearing necessary. During the trial, the court, on its own initiative, or on request of a party, may announce its intention to take judicial notice of any matter and allow the parties to be heard thereon. After the trial, and before judgment or on appeal, the proper court, on its own initiative or on request of a party, may take judicial notice of any matter and allow the parties to be heard thereon if such matter is decisive of a material issue in the case. 2. There are matters in a litigation which admitted without need for evidence, for example, when complainant in a criminal case alleges that he was assaulted by the accused in Quezon City, it would be ridiculous to require the prosecution to prove that a place called Quezon City exists. Also, if the accused is charged with the violation of a statute, there is no need to introduce evidence that said statute exists because the court is charged with knowledge of the law, it being the product of an official act of the Legislative Department of the Philippines. There is, likewise, no need to adduce evidence to prove that there are 24 hours in a day or that the sun rises in the east and sets in the west. The fact that Cebu lies in the Visayan region needs no further evidence. To require evidence for such obvious facts would be totally absurd. Now, all these matters which the court may take cognizance of without evidence are called matters of judicial notice. 3. Judicial notice is based on the maxim, what is known need not be proved, hence, when the rule is invoked, the court may dispense with the presentation of evidence on judicially cognizable facts. Thayer, Preliminary Treatise on Evidence, p. 277 cited in Jones, The Law on Evidence in Civil Cases, Volume 1, 3rd ed. 4. The taking of judicial notice is a matter of expediency and convenience, for it fulfills the purpose that the evidence is intended to achieve, and in this sense, it is equivalent to proof. Land Bank of the Philippines v. Yatco Agricultural Enterprises, Gr. No. 172551, January 15, 2014. Function of judicial notice. Judicial notice takes the place of proof and is of equal force. It displaces evidence and fulfills the purpose for which the evidence is designed to fulfill. Hence, it makes evidence unnecessary. Moran, Comments on the Rules of Court, 1980, p. 38 citing Alzua v. Johnson, 21 Phil. 308. When the court takes judicial notice of a matter, the court accepts and recognizes the same without necessity of formal proof. Evidence shall be dispensed with because the matter is so well known and is of common knowledge not be disputable. When judicial notice is mandatory. 1. A matter of judicial notice either be mandatory Sec. 1 Rule 129, Rules of Court, or discretionary Sec. 2 Rule 129, Rules of Court. When the matter is subject to a mandatory judicial notice, no motion or hearing is necessary for the court to take judicial notice of such matter because it is what it says it is mandatory. 2. The following are matters subject to mandatory judicial notice: a. Existence and territorial extent of states, b. Political history, forms of government and symbols of nationality of states, c. Law of nations, d. Admiralty and maritime courts of the world and their seals, e. Political constitution and history of the Philippines, f. Official acts of the legislative, executive and judicial departments of the Philippines, g. Laws of nature, h. Measure of time, and I. Geographical divisions. 3. It would be error for a court not to take judicial notice of an amendment to the rules of court. In a case, the Supreme Court declared that even if petitioners did not raise or allege the amendment of the rules of court in their motion for reconsideration before it, the Court of Appeals should have taken mandatory judicial notice of the Supreme Court's resolution in AM No. 000203 SC amending Sec. 4 of Rule 65, effective September 1, 2000. Under Sec. 1 of Rule 129, a court shall take judicial notice, among others, of the official acts not only of the legislative and executive departments but also of the judicial department. Sienna Realty Corporation v. Gao Lang, 428 SCRA 422. It is axiomatic that a court has the mandate to apply relevant statutes and jurisprudence in determining whether the allegations in a complaint establish a cause of action. While it focuses on the complaint, a court clearly cannot disregard decisions material to the proper appreciation of the questions before it. In resolving the motion to dismiss, the trial court should have taken cognizance of the official acts of the legislative, executive, and judicial departments because they are proper subjects of mandatory judicial notice as provided by Sec. 1 of Rule 129 of the Rules of Court DENR v. DENR Region 12 Employees, 409 SCRA 359. 4. In a case questioning the title of the University of the Philippines to certain lots, the court ruled that the lower courts should take judicial notice of the fact that Congress and the Supreme Court have both officially recognized the university's indefeasible title to its landholdings. The official acts of the legislative, executive and judicial departments of the Philippines are matters of mandatory judicial notice. Republic of the Philippines v. Rosario, Gr. Number 186635, January 27, 2016. When judicial notice is discretionary, Bar 2012. 1. Under the principle of discretionary judicial notice, a court may take judicial notice of matters which are of public knowledge, or are capable of unquestionable demonstration, or ought to be known to judges because of their judicial functions. Sec. 2 Rule 129, Rules of Court. 2. The principal guide in determining what facts may be assumed to be judicially known is that of notoriety. Hence, it can be said that judicial notice is limited to facts evidenced by public records and facts of general notoriety. Moreover, a judicially noticed fact must be one not subject to a reasonable dispute in that it is either 1. Generally known within the territorial jurisdiction of the trial court, or 2. Capable of accurate and ready determination by resorting to sources whose accuracy cannot reasonably be questionable. Things of common knowledge, of which courts take judicial notice of, are matters coming to the knowledge of men generally in the course of the ordinary experiences of life, or they may be matters which are generally accepted by mankind as true and are capable of ready and unquestioned demonstration. Thus, facts which are universally known, and which may be found in encyclopedias, dictionaries or other publications, are judicially noticed, provided they are of such universal notoriety and so generally understood that they may be regarded as forming part of the common knowledge of every person. As the common knowledge of man ranges far and wide, a wide variety of particular facts have been judicially noticed as being matters of common knowledge. But a court cannot take judicial notice of any fact which, in part, is dependent on the existence or non-existence of a fact of which the court has no constructive knowledge. Expertravel and Tours, Inc. v. Court of Appeals, 459 SCRA 147. 3. The power to take judicial notice is to be exercised by courts with caution, especially in an expropriation case which involves a vast tract of land. Care must be taken that the requisite notoriety exists, and every reasonable doubt on the subject should be promptly resolved in the negative. Land Bank of the Philippines v. Waikoko, 419 SCRA 67. In Waikoko, the trial court, in arriving at the valuation of the land, took judicial notice of the alleged prevailing market value of agricultural lands in the place without apprising the parties of its intention to take judicial notice thereof despite the requirement of a hearing under Section 3, Rule 129 of the Rules on Evidence. The Supreme Court, in the same case, held that, inasmuch as the valuation of the property is the very issue in the case at bar, the trial court should have allowed the parties to present evidence thereon instead of practically assuming a valuation without basis. Judicial notice and knowledge of the judge, Bar 1080, 2011. 1. Judicial notice may be taken of a fact, which judges ought to know because of their judicial functions. Sec. 2 Rule 129, Rules of Court. But judicial notice is not judicial knowledge. The mere personal knowledge of the judge is not the judicial knowledge of the court, and he is not authorized to make his individual knowledge of a fact, not generally or professionally known, as the basis of his action. Slate Prosecutors v. Murrow, 236 SCRA 505, Land Bank of the Philippines v. Waikoko, Supra. 2. Judicial notice is not limited by the actual knowledge of the individual judge or court. A judge must take judicial notice of a fact if it is one which is the proper subject of judicial cognizance, even if it is not within his personal knowledge. Consequently, a judge may not take judicial notice of a fact which he personally knows if it is not part of the evidence or not a fact generally known within its territorial jurisdiction. 29 Amur, Evidence, Section 35, Moore v. Dresden Investment Cos. 162 Wash, 289, 298 Pac. 465, 77 ALR 1258 cited in Jones, The Law of Evidence in Civil Cases, Vol. 1, Section 132. Stage when judicial notice may be taken. The court can take judicial notice of a fact during or after trial pursuant to the procedure in Sec. 3 of Rule 129 of the Rules of Court, as follows. 1. Judicial notice may be taken during the trial of the case. The court, during the trial, may announce its intention to take judicial notice of any matter. It may do so on its own initiative or on the request of any party and allow the parties to be heard. Sec. 3 Rule 129, Rules of Court. 2. Judicial notice may also be taken by the proper court after the trial, and before judgment. Judicial notice may also be taken on appeal. The proper court, on its own initiative or on request of a party, may take judicial notice of any matter and allow the parties to be heard thereon if such matter is decisive of a material issue in the case. Ibid. Judicial Notice of Foreign Laws, Doctrine of Processual Presumption, Bar 1997, 2005, 2011. 1. It is well settled in our jurisdiction that our courts cannot take judicial notice of foreign laws. Like any other facts, they must be alleged and proved. Australian marital laws, for example, are not among those matters that judges are supposed to know by reason of their judicial functions. Garcia v. Garcia-Recchio, 366 SCRA 437. Thus, a party who wants to have a foreign law applied to a dispute or case has the burden of proving the foreign law. Del Socorro v. Van Wilson, Gr. No. 193707, December 10, 2014. In general, and in the absence of statutory requirement to the contrary, the courts of the forum will not take judicial notice of the law prevailing in another country. 29 Amur, Evidence, Section 116. Foreign laws must be alleged and proved. In the absence of proof, the foreign law will be presumed to be the same as the laws of the jurisdiction hearing the case under the doctrine of processual presumption. Northwest Orient Airlines v. Court of Appeals, 241 SCRA 192. For instance, the court cannot determine whether the termination of plaintiff is in accordance with Singaporean law because of the failure to prove the applicable law of Singapore. Philippine courts do not take judicial notice of foreign laws. In the absence of evidence of the law of the foreign country, Philippine laws should be applied under the doctrine of processual presumption. Riano v. Court of Appeals, 324 SCRA 414. 2. It was, however, held that where the foreign law is within the actual knowledge of the court, such as when the law is generally well known, had been ruled upon in previous cases before it, and none of the parties claim otherwise, the court may take judicial notice of the foreign law. PCIB v. Escalon, 56 SCRA 266. Judicial notice of the law of nations. When the foreign law refers to the law of nations, said law is subject to a mandatory judicial notice under Sec. 1 of Rule 129. Under the Philippine Constitution, the Philippines adopts the generally accepted principles of international law as part of the law of the land. Sec. 2, Art. Il. Constitution of the Philippines. Being parts of the law of the land, they are, therefore, technically, in the nature of local laws and, hence, subject to a mandatory judicial notice under Sec. 1 of Rule 129. Judicial Notice of Municipal Ordinances, Bar 2005, 2011. 1. Municipal trial courts should take judicial notice of municipal ordinances in force in the municipality in which they sit. U.S. v. Blanco, 37 Phil. 126. 2. A court of first instance, now RTC, should also take judicial notice of municipal ordinances in force in the municipalities within their jurisdiction, but only when so required by law. For example, the Charter of the City of Manila requires all courts sitting therein to take judicial notice of all ordinances passed by the City Council, City of Manila v. Garcia, 19 SCRA 413. The RTC must take judicial notice also of municipal ordinances in cases on appeal to it from the inferior court in which the latter took judicial notice of U.S. v. Hernandez, 31 Phil. 342, U.S. v. Blanco, Supra, Moran, Comments on the Rules of Court, 1980, p. 42. 3. The Court of Appeals may take judicial notice of municipal ordinances because nothing in the rules prohibits it from taking cognizance of an ordinance which is capable of unquestionable demonstration. Gallego v. People, 8 SCRA 813. Judicial notice of a court's own acts and records. A court will take judicial notice of its own acts and records in the same case. Republic v. Court of Appeals, 277 SCRA 633. See you next slide. Thank you.